Hi, I'm Debbie Moraes, and this is Legal Matters, a program designed to address critical issues that are facing consumers and businesses today. It's legal information, it's practical solutions, and straight talk on a variety of topics. As you've seen, we've been discussing issues from finance and family to Social Security and workers' compensation and more. And in our last segments, we had begun to discuss the divorce, and we realized that it was going to be more than one topic, one session. So from the division of assets to the anguish for children and everything in between, it's a painful and upsetting event for many of you, and hopefully it is going to be a process that our lawyers can help us manage. So as we had closed the segment last time, we say please send us an email question, and once again we have our attorneys Jackie Grasso and David Bazaar with us to address the last questions that were presented, and they are?
Jackie, you received the email this time.
I received an email that had a question about when a person can file for a divorce. The question read that she and her children have moved to Rhode Island and have only been here for 6 months, and she wants to file for divorce, and is she able to file for divorce?
So in Rhode Island, there's a 1-year jurisdictional requirement to file for a divorce. If you haven't lived in Rhode Island for more than a year and she's been here 6 months with children, she could file a couple of different petitions short of a divorce that could deal with custody, support, and even a separation, divorce from bed and board, we would call that. She can't file for divorce yet unless her husband's lived in Rhode Island for more than a year, or if he's still in Massachusetts, where they came from, she could file en masse on his jurisdiction. Exactly.
And in Massachusetts, the residency requirement is 1 year as well. If you can't get in on, for the divorce purposes, then for children, you can at least go in and file a petition for child support, because if the child reside in a state with a parent for 6 months or more, then that state would have jurisdiction to hear matters pertaining to the children.
Right.
That's good to know. And are there other questions, or that was?
I think that was the only one received.
That was the only one. Yeah.
Okay.
And I think that's a good point where you left off with the children, because I think so far that's what we've talked about was custody and visitation and that type of thing. And there's so much more to divorce that we didn't have enough time to cover it all, never mind the entire jurisdiction of family court.
So you refer to it as substantive and process. Where do we want to begin?
Well, I think we were talking more right now of the substantive law, which is people's rights, as opposed to the procedural law, which we were talking a little bit about just now with the process. So we should finish giving a little description of what some of people's rights are and what they can expect as they go through a divorce process.
Fair enough.
Right. So we talked about custody, we talked about visitation. Once those things have been determined, I think the next thing the court might look at is equitable distribution, dividing up of the property. And we may have spoken a little bit about that last time as some of the issues that go into it. In Rhode Island, at least, I'd say we look at it as a 50-50 proposition to start. Any property that's been acquired during the marriage goes into what we'd call the marital pot. So the first thing you have to determine is what goes into the marital pot, what's part of the assets that are subject to division, and what's not. In Rhode Island, if you own something prior to the divorce, that asset doesn't go into the pot. An increase in value may, but the asset itself does not go in. If you acquired something by gift or inheritance from your parents or otherwise, that also is not subject to distribution of the asset. Again, you could look at the increase in value.
So is that what they refer to as the non-marital asset if it were a gift?
Correct. Rhode Island's an equitable distribution state. So the first thing you have to look at is what is going to go into the pot for equitable distribution.
Because there are some exceptions to the equitable distribution in the non-marital property. Certainly if somebody receives a gift or inheritance throughout the marriage and they take that asset and commingle it with their spouses, for instance, you get a CD, certificate of deposit, and you receive it through inheritance. You then take that money, roll it over into your own bank account, and put your spouse's name on it, and you use it for whatever reasons throughout the marriage, use or no use. That is now called a transmutation.
Right.
So with that, you have now taken a non-marital asset, commingled it, and made it a marital asset.
Right, you've changed the character of that asset by doing that. And you can do that with, there's a case in Rhode Island where property that was inherited, furniture and things of that nature, which is difficult not to commingle if you put it in the house and both spouses use it.
Dupre or Stevenson, or both.
Yeah, the name on that
cases.
one's going to escape
Yeah.
me. Quinn versus Quinn, I
Quinn
think it
versus
is.
Quinn. Okay.
But in any event, so we have to first determine what the pot is. So once you've gone through all the assets and determined what goes in, what doesn't, and now Jackie's raised a couple of interesting points. Some clients will come in, and I know you must hear this all the time too. Well, I'm the one working. I put my money into the 401k. That's my money. That's not my wife. She has no interest in it or whatever. That's not so. We don't look at whose name is on the property necessarily, except in the case that Jackie mentioned where you inherited and then added your spouse's name, but how the property was acquired, when it was acquired. So if you acquired during the course of your marriage a 401k, your spouse's name's not on that. It's still part of the marital estate.
Yeah, I think it's important to point out too, especially with a lot of housewives or stay-at-home dads, if they don't work, they automatically assume that they're not entitled to anything in a divorce. Non-monetary contributions are as important as a monetary contribution, and there are a number of factors that the court needs to consider to equitably divide assets. It's called the equitable distribution statute. One is monetary contribution, non-monetary contribution, station in life, your age, your health, your occupation, your employability, and go on and on. There's about 16 or 17 factors, a little bit more in Massachusetts. But that's what the court needs to determine in deciding who gets what in the divorce.
Yet, while we spoke last time about this being a no-fault state, and I assume that means Massachusetts as well, does that no fault mean even if there was some unsavory activity, will that impact on what is then considered to be the equitable distribution of assets?
It's a good question, and let me explain where the confusion comes.
It varies between states.
Yeah, but in Rhode Island, in terms of no fault in Massachusetts as well, that is the grounds for divorce. And I think we spoke a little bit before. Yes. Historically, you had to prove fault in order to get a divorce. You don't have to prove that ground anymore. It can be simply in Rhode Island irreconcilable differences that have caused the irremediable breakdown of the marriage. In Massachusetts, do you call them irretrievable?
Irretrievable breakdown.
Right. And that's the grounds for divorce. But fault does play a role as one factor of many in Rhode Island in equitable distribution. Conduct is listed as one of the factors that the court can look at.
And the others I mentioned, age and
right.
occupation, yeah.
And so, in fact, for many cases, conduct is the only real issue that gets tried. There are many exceptions to that. How the property was acquired, if it was a family business or family asset that you bought during the marriage, where that came from may be a factor in a judge's decision in how to divide an asset up. But conduct is the one that you see and people come in to talk to you about all the time. I want all of the assets of the marriage. My husband, my wife cheated on me. It doesn't happen that way, but that's, you know, the issue that we're always talking about with clients, or often talking about.
And is that the thing that might also give someone, I suppose it's not supposed to be this way, but leverage as to who gets custody of the child?
Well, it's not
a bad person?
There's actually case law or ethical decisions in Rhode Island about that. If a lawyer, or not, I shouldn't say a lawyer, but if an individual purposely uses custody as a threat to either obtain more assets, then that's not going to work.
No.
It's not going to work.
You can't.
The courts see right through that.
It's not ethical to use custody as leverage in equitable distribution. Yep. Custody, we talked about last time, there are a number of factors. Conduct of the parties, you know, depending on what the conduct is, can or cannot be an issue in what's the best interest of the child for placement. I mean, if the conduct is very bad behavior, including drug use and alcohol abuse and whatever else it might be, a judge may be very concerned about having even visitation for that parent with the child, let alone custody. The factor of conduct in equitable distribution is a little bit different. It may not even rise to the level of a concern about visitation as it could, but it could be something that led to the breakdown of the marriage. If you're the cause of the breakdown of the marriage,